hello, everybody. I have a program here today I think you're all going to enjoy. I have Dr. Jay Irby. He's the director of the mediation program in Stillwater. He was born and raised in Oklahoma, the son of a Methodist minister from the Tulsa area, whose subsequent career as retirement home administrator took his family to Athens, Georgia, Topeka, Kansas. Jay attended the University of Kansas, where he received his doctorate, so he's Dr. Jay Irby, in community mental health settings in Louisville, Kentucky. For 19 years, Jay joined the clinical psychology facility at the University of Louisville and is the assistant professor teaching undergraduate and graduate classes. He returned to Oklahoma 7 years ago to be closer to his family, began volunteering as a mediator with the Early Settlement program in Norman. Since July 2018, he has been the director of the Early Settlement North program in Stillwater, where he trains and coordinates volunteers providing mediation services in Kay, Lincoln, Logan, Noble, Pawnee, and Payne counties. He's with us today to talk about the Early Settlement Mediation program, how you can become a volunteer, because I know a lot of you like to mediate, and you can be a volunteer for the program. This program is under the Supreme Court system, the administrator of the courts, and it is sponsored and supervised by the county, and I supervise that program. And my daughter is the assistant state director of that program. So I'm going to introduce you to Dr. Jay Irby and let him tell you a little bit about how his program helps mediations and how you can be a volunteer.
Thank you. Can you all hear me okay? Okay, then I'm going to turn that one down. Well, thank you, Glenna, Mr. President. Ladies and gentlemen, it's good to be in a room of people that are of service to other citizens. And here's a little bit of trivia for you. Which state of the union has a statewide alternative dispute resolution system that is absolutely free for all the citizens of the state? Oklahoma. It's one of the hidden gems of our state that back in the 80s we did really well. Now, there's a lot of alternative dispute resolution or mediation services that are nonprofit organizations in different cities. There are different court systems that have mediation. Some cities have it as a part of their civic functioning. A lot of private mediators. Kansas has one person who hires private mediators for mediations in their state. But we're the only state in the country that actually has a court-connected, sponsored, and our board is made up of folks that have been a part of the administrative offices of the court. The Supreme Court sits on our board, and we're a community-based. We actually move out into the different communities in the state, and our volunteers do our mediation. So that's one of the ways that we have so much success, is we've got people from the communities where folks in crisis or in conflict are living that are able to help their fellow citizens. So the Early Settlement Mediation Program is a part of this system, and it's nationally recognized as implementing kind of state-of-the-art level mediation in the civil setting. We have 13 regional programs that are based in early settlement offices that are administer grants that from the administrative offices of the court to staff and fund those programs. Glenna and the county clerk have been sponsoring our program. Other programs are sponsored by universities and county commissioners. We have 2 child permanency program offices in Tulsa and in Oklahoma City, and I'll talk a little bit about what child permanency is about. It's a special kind of mediation that we've just recently begun to do in a certified and pretty consistent way. And in the last couple of years, we've had an initiative to develop what we call a peer relations in Oklahoma schools, or PROS program, that introduces curriculum and training to school systems across the state that promote peaceful conflict resolution, active listening. It's really training and encouraging students to begin to practice some of the things we as mediators know are very successful in resolving conflicts and not allowing them to escalate. So we're very proud of that program, and it was pretty widely accepted in many different school systems. As Glenna mentioned, I'm the director of the program here in Stillwater, and we cover kind of a strip of things east of the I-35 corridor, from K County through Lincoln, Logan, Noble, Pawnee, and here in Payne County. A little bit of history about the ADRS, or Alternative Dispute Resolution System. It was actually instituted by the Dispute Resolution Act of 1983 that identified a funding source for us of a $2 fee associated with every civil filing across the state. And that funding mechanism has been a part of our program, and it's one of the things that make us pretty unique. We don't have to spend as much time as many of the other nonprofit mediation services across the country have to do in fundraising to keep their doors open. This statute introduced the rules and procedures that have governed our programs ever since, and it embodied a 15-member advisory board that meets about quarterly to oversee our policies and maintain our accountability to our mission. Through the 90s and the 2000s, we extended this service to all 77 counties and introduced an advancement of our mediation. We started doing just civil cases, small claims cases, real estate cases, things like that, but we were able to move into doing family and domestic mediations for couples that are seeking a divorce, going through a divorce, or needing to make a modification of a child component after a divorce. And we also began the child permanency mediations that I'll tell you a little bit more about here in a minute. And through the 2010s and surviving the pandemic, we've continued to increase the use of mediation in all the district courts across the county. We're getting close to 5,000 cases a year that are mediated through all of our different programs. And our funding was increased to a $7 filing fee that is reserved, or I don't know what the budgeting term is, but it doesn't go back into the general fund every year. We were able to carry it over, and it was because of that funding mechanism that the legislature created in the 80s that our programs were able to survive the pandemic and the impact that had on our services. We got into doing mediations online so that folks' divorces didn't get delayed for the year or more, 2 years. I've seen some courts delayed in resolving a divorce during that particular time. And we also introduced some training videos that are an integral part of the way we train new volunteers now. This is a map. I'll show you a link that you can scan to our ADRS webpage from the Office of the System of the Court, Supreme Court Network. This is how the 13 programs are distributed across the 77 states, or 77 counties. And that little light green strip is the communities that my program serves. You can see we've got a very big program out through the Panhandle, and through the middle part of the state and the southwest. And then population is a little more dense in the eastern part of the state, so we've got some programs that are kind of demarcated around those population centers. On our web page, this map appears, and consumers can actually click on the county that they have a situation in, and that will take them directly to the web page for that particular program, where we've gotten some online resources to schedule a mediation, to collect intake information, to provide forms, consent forms, and confidentiality agreements for folks to do before mediation. So being online has really facilitated our mission to make mediation available to as many people as possible. So what we do is any kind of conflict. Most of our issues come from a court case. Judge Thomas, who does the small claim dockets here in Stillwater, has 3 or 4 mediators every session and pretty reliably sends landlord-tenant concerns, business-consumer concerns, lending issues and whatnot to the mediators that we have right there on the docket that can work out an agreement that resolves a case and allows parties to put their conflict in their rearview mirror. And that continues to be our basic service across the state. Now, some counties don't have as much small claims kind of activity as Stillwater and Ponca City and Chandler tend to have. But in addition to those kind of civil cases that come through the courts, we're also available to real estate agents as a part of the contractual agreements. There, if there's a contention or a conflict, one of the things that they're encouraged to do is to seek mediation. And we do that with real estate agents and all across the state. And we've got people that are wanting to settle a divorce. They want to make a change in their child custody provisions of a divorce that they want to modify, that have been able to come to us without necessarily engaging an attorney, no offense, Jonathan, but we can help them create an agreement that then they can take to somebody like Jonathan or other attorneys to provide the court records that individuals need to make those kinds of changes in a divorce. And I've actually done one or two of those where my background as a clinical psychologist kind of seeped in, and the folks decided they didn't necessarily want to get a divorce. They thought they'd give it an extra try. But the family and divorce cases are a little more complicated. We have to deal with family relationship issues, how children are going to spend time from one household to another, who's going to have the decision-making authority. And then everybody has to divide their property and assets and debts associated with it. So we take a little bit more time to do the training for folks doing those kinds of mediations. And we do something for those cases that we don't necessarily do for most of the basic cases, and that is we reach out and talk to people ahead of time, helping them understand what they're getting into, how to prepare for the often emotional experience of going through mediation around their divorce, as well as to assess for risk factors like domestic violence, substance abuse, or mental health issues and basic safety issues that can sometimes influence people's willingness to be in a room working with the person that they're separating from. Adult guardianship is one that I haven't seen done as much here as in Kentucky, where I previously practiced. In that state, for an adult to be declared a ward of the state, an interdisciplinary team had to evaluate them, a social worker, a psychiatrist, and a psychologist, and I served that function for several years for the court there. And a jury, a 6-person jury, had to make the decision about whether the person was incompetent or not. Oklahoma's got a very different way of doing that, but sometimes families can get into a dispute about the decisions being made on the behalf of an elderly or impaired individual. And sometimes an individual that's been bringing up a person with a developmental disability, and that child turns 18, in the eyes of the medical profession, they are an independent adult, unless a guardian has been appointed in their best interest. The child permanency is one of that we've started to do in the last 5 years or so. These are cases where a child has been removed from a family for a variety of reasons, and the court has had a clock going for that child to have a permanent placement, either a reunification with the parents or a placement or an adoption in a foster home or establishing a guardianship. So these kinds of mediations are, there's a lot of people in the room. Every parent has an attorney. There's an attorney for the state, DHS, and the court services. CASA and others can also be there, as well as all the family members that are there. So it's a challenge, but it's a very rewarding one when folks who are dealing with real significant kind of Sophie's choice kind of questions are able to come to a plan where families are not divided, they actually become a little larger because more than one person is going to have a parental kind of involvement or an adult involvement with the children. And then I mentioned the peer mediation program that's now available in many of the school systems across the state. Last year, in our fiscal year that ran to June of 24, most of our work here in our program was in the civil area. We got 136 cases referred. We were able to mediate 135 of them, and 61% of those cases reached an agreement that resolved their case. Our program has led the other programs until recently in the number of family cases that we did. We get referred 289. We were able to see 231. We don't have as many of them that are referred that we actually see. They'll drop out, there'll be reconciliation, or there may be ways in which we're not able to serve them. But of the 231 people that we've worked with, 74% of them reached an agreement that resolved their case and saved them money, helped them avoid a trial, and facilitated a repair of their relationship. And then the permanency case, we've really got 3 counties where we do these, Lincoln County, Stillwater, Payne County, and up in Kay County. And last year we had 22 referred, we saw 21, and I'm the one that does most of those cases, so that 76% agreement rate is something I'll take a little credit for. But those are pretty remarkable numbers when you think most of the statistics that are collected by other large mediation programs are very lucky if they get over 50% of agreements. A little bit better, much better. We do much better than Chance. What makes our services possible are the volunteers that train and become very dedicated providers of this very important and impactful service to the community. Over the years, we've had 3,000 people on our roster as completed the training and actively engaged in mediations. In any one year, we've had around 350 or more that are actively involved. And I'll tell you, the volunteers that I've worked with since I've been here it's becomes a mission for them. We have a kind of an hour's expectation for return on the training time that we invest. But most of these mediators are doing 4, 5, 6, 10 cases a month and are contributing to this really important success rate that we have. When we begin with an individual interested in this form of service, they engage in a training process. It takes about 20 hours. It's online, so a lot of the kind of content can be consumed on your own time. And the actual in-person training that we do in kind of a hybrid model involves a lot of role-playing and the ability to practice what it's like to be a mediator and how to go through some of the steps of the mediation process that I'll describe here in a minute. The family training is because the issues are a little bit more complex and more emotional. There's more psychological factors that are involved in those kinds of conflicts. That training is a little longer. It's about 3 days, 4 days that we do twice a year in January and August at the law school at OU. And for the basic training, we ask you to give us about 20 hours over the next 2 years. For the family, we really want folks to can pay back or contribute about 40 hours of service. And that's an expectation that goes about 3 years. But I've had every mediator I have right now got their 40 and more in their first year of mediating. They really get hooked on it. The child permanency and adult guardianship, we've created with my colleague Tim Scott, a training model for that as well that can be seen online. And then there's a supervision process where a certified mediator will sit in with a new mediator. They co-mediate together. They can be there as a resource when the volunteer actually takes a solo flight and deals with the mediation from beginning to end on their own. And then once they're comfortable doing that, we provide a certification and they go to work. This is also a program that's permeated 90% of the state offices now have an internal mediation system for employee-employer complaints, other kinds of issues. We've got folks that have been trained within each of these state agencies to do some cross-agency mediation. If there's an issue in one particular office, a mediator can be made available from another state program so that that person is completely neutral and uninvolved in the situation that may be a part of the mediation. We also have an extern program in the 3 law schools here where law students are able to do this for a semester. They go through the training, they work with the program director, and actually then leave the extern program having been a mediator in a way that helps change the legal culture around mediation in a very profound way. If you've been taught about it when you're actually in practice, it's not a threat to you. It's not an alien kind of experience that lawyers feel somebody's trying to take my job away from me or dealing with my bottom line. Many attorneys attend mediations in family and divorce cases and can charge a fee for that, but most folks who've been regular users of mediation for their domestic issues realize it actually is a force multiplier for their practice because they're able to resolve cases and get new cases and new retainers flowing through their office in a way that they weren't able to do before when a case got stuck and they got involved in sending orders against each other and fighting things out. We're able to help them actually make more money. The parties come to a successful agreement, and the judge is happy because the case is off their docket, and they're not having to face a trial. So what kind of person can do this? It's a very meaningful volunteer opportunity, but it is one that is easy to learn. But I'm often asked, well, what do you look for when you're looking for a mediator? And with a shout out to Jeff Foxworthy, I'd say that if people tell you that you're a good listener, and that folks tend to come to you to talk about their issues and value your feedback whenever they really feel heard by you when you listen. If you're pretty level-headed, if you're one of those people that keeps calm and just carries on. When other folks, if it's getting loud, you're getting quieter. If you're able to kind of stay level-headed in the face of strong feelings, and fairness is an important value to you. If you're pretty even-handed, you want to make sure that everybody has an equal participation in coming to an agreement or addressing the issue in conflict. If you're a people person, if you're really curious and you like being around people and you easily meet individuals and you like figuring things out, or more importantly, you like helping other people figure things out by being what we call a decision coach. Mediators help people understand what kinds of things they could do and what kinds of things may not be possible. They're able to check out the reality testing of any proposal or position they may have in mediation. And mediators can learn how to ask the questions that make the answers clearer for folks when they're doing the problem solving. If people say those things about you, if you think they are describing you or more importantly, somebody you know, well, you just might be a mediator. And come volunteer with us and I'll help you find out. So if you're interested, I'd be more than happy to talk with you, but I've also put some flyers on the table. If you know somebody that you would like to sit in the room with somebody that you're in a fight with and that you would trust to treat you both fairly, that's the kind of person I'd like to meet because they're the kind of person that can really find a very rewarding experience in working with our programs. Like I mentioned, that process involves contacting each one of the regional program directors like myself, and then we work through the basic training, working on making sure you have role play experiences, that you have exposure to the slides and the content of the training. And then you go through the process of co-mediating till you're comfortable mediating on your own and become certified and active yourself. We usually like folks to kind of do the basic level things so they're really comfortable working with the model that I'll describe before they actually get into family training. Now, I was a bit of an exception to that. When I was working in Norman, I was fortunate enough to let them know I had actually been trained as a mediator when I was in graduate school in the University of Kansas. So I was one of the people when the director in Norman heard about me as a volunteer, or I reached out to her and asked to become a volunteer, she sent me to the basic training and the family training in the same week, and got me busy as a family mediator pretty quickly. That's why we try to find the way to individualize the training model, so that when you're a volunteer and you're dealing with these things that conflict can be a little uncomfortable, takes a little getting used to. It's a unique role that a person is in as a mediator. It sometimes takes a little time to learn. You got to turn off your engineer hat or your lawyer hat or your social work hat or whatever, and put on a mediator hat and learn how to be that way with other folks in conflict. So we want to individualize your training to maximize your effectiveness and success and satisfaction as a mediator. Our state, the people we work with, they're not paid, they're not professional or private mediators, but they do agree and hold themselves to some very important ethical standards that are central principles of the mediation movement. And the first is that people can figure things out on their own. People have the right to make decisions to resolve the conflicts in their life on their own terms, or at least have a chance to do that before somebody else intervenes and makes decisions for them. And the process of mediating is one that everybody is voluntarily engaging in. Nobody has to do mediation. Many times a judge will order you to attend, and as soon as you walk in, you've met the requirement of the judge's order. Your participation in the process is always entirely up to you. Our mediators don't have any other kind of conflict of interest or dual relationships with the parties we mediate with, but there are times in which a mediator will work with a family and they've devised a kind of interim plan, some things that they need to do before they can finalize their divorce, and they come back to mediation after they've kind of followed that plan, and many times the same mediator will work with them, so their familiarity with the case, the trust that's been built up in their earlier mediation can be capitalized on as they try to conclude things. Our mediators, we work hard to stay neutral and impartial, to treat what we do for one, we do for the other, and our judgment and our own human reactions to the things that we hear in the room are held in abeyance in the interest of allowing the full exploration of every party's viewpoints with respect. And we don't accept any kind of remuneration as volunteers. I have a salary, and our mediators have the ability to kind of turn in mileage if they're making trips out of the county, but we're not doing this for profit. We're doing this for service. So when you do this mediation, there's about a 4 or 5 step experience. Initially sitting down, getting to meet your mediator, completing some of the formal consent forms and confidentiality, reviewing some ground rules before the parties move into the actual discussion part. One of the basic ground rules of mediation is that one party speaks at a time without interruption and without any name calling or attempts to provoke an argument. So many times, this is the first time, because of that very simple rule, and the second one, which is that they speak to the mediator and not to each other, unless the mediator gives them permission to do that. It's the first time they've actually heard the other person's viewpoint without, waiting for them to stop talking so you can tell them where they're wrong. It kind of creates a circumstance in which people actively listen to learn and understand that some things can look different to another person, or other things may be important to that person that you weren't aware of until they actually had a chance to say it in front of you in the mediation. In that stage 2, we're getting both sides' views, and we're getting kind of an agenda of what are the issues that they need to make decisions about. And that's when we get into the stage 3 and 4, which is the problem-solving stage. One of the problems that a couple divorcing may identify is how are their children going to get from one household to the other when one parent lives in Stillwater and the other one lives in Cushing. So that we kind of identify that's one of the issues. Then when we're in 3 and 4, we start exploring the different options. How can that child make that trip, especially when they're not driving themselves? And there's several ways that can happen. You know, the receiving person who's getting the physical custody can make the trip and pick them up. And then the other party will go back and pick them up. So every time the travel is incurred by one or the other parties, or both of them in an equal way, or they can meet halfway, okay? Or a solution a lot of folks are doing now is that they're picking up, if they've got like a weekend visitation, that person picks up the child after school on Friday and takes them back to school on Monday morning. And there's not any interaction between the parents that might provoke an ongoing kind of tension. That's kind of what we're doing in that session for all kinds of problems, like how you divide your retirement, how you sell your home. We give them an idea of what kinds of solutions might work. Then you pick one. You figure out, well, let's give that a try, or this might be the thing that works for the two of us. And then we finalize that, reality test it, and put it in a written agreement that each person has a copy of, and that can be used by an attorney to prepare a modification or divorce decree. And this is something I know Jonathan's done many times with us and for his own clients. Take a screenshot here of the QR code and keep it in mind. If there's somebody that you think would be a good mediator, or if you're interested, I'd be more than happy to talk with you. I hope this has helped you understand a little bit better what early settlement mediation is all about, and what kind of service opportunity we provide for the citizens of Payne County and all the other counties in the state. Thank you very much for your attention, and I'm open to any questions you might have. Thank you.
Can you tell us about the most interesting case you've ever mediated?
Well, one reason I like this job is that the most interesting case I've ever mediated is the next one I'm going to mediate. Okay? There are some that are kind of legendary. You know, one of the first ones I did for Judge Arberg over in Cushing was a barking dog case. That's kind of a classic circumstance where neighbors are complaining about a dog that's barking. This was folks that police had been involved with several times because of how heated the complaint had been. Turns out when I sat down with them and we did this model, the young man who owned the dog had lost his father that year and was really depressed and unable to do some of the structural things that he needed to do for his dog. And the neighbor who was making all the complaints was the best friend of the father who'd passed away. And we were able, just by sitting in the room with somebody that you had to talk to instead of to each other, and who helped you talk about the issue in a way that helped you understand the human dimensions from both perspectives, they reconciled and came to a really nice arrangement of the complainant having access to the other person's yard in order to let the dog out and let the dog in. They were really collaborating with each other, shared walks. They hugged at the end of the mediation. These were folks that were trying to get each other in jail. It's a very powerful experience. And then there are people that have fought over their grandmother's quilt. Get everything settled, but they can't decide that. And then Jonathan and some of the other attorneys get in, well, maybe we need to do everything else. Yes, sir.
During these mediation service sessions, is there an officer of the court present at all?
We are.
You are, okay.
We are acting as...
At what point does that go before a judge to be certified or whatever? Or
well,
does it?
for the civil cases, we're able to record that on a form that actually has everybody's signature in a place for the judge to sign. So when we do like a small claims mediation during a docket, the parties will bring that back to the judge. She'll review it with them, and when she signs off on it, then that's the order of the court. I did a civil case, a CJ case, where there was, I think, $50,000 complaint against each other. I did a case like that in Pawnee, and the judge actually stuck around for the afternoon. It was Friday afternoon, and we got an agreement, and he was able to sign off on it, and they resolved that case in a very equitable way. Now, it's different for the family. We're not wanting our documentation to serve as a divorce decree. there's a lot of things that need to be in a decree that we don't need to mediate about. So we provide an unsigned, what we call memorandum of understanding, that everybody gets a copy of and that can be used by an attorney to record things like meeting halfway when they're going to transfer the kid. Does that answer your question?
if they don't follow through after the agreement is made?
Well, you wind up back in court. Sometimes they'll call our office and we'll help kind of remind people of their obligations and whatnot. But nothing about the mediation impairs your ability to seek justice for your property or funds. If you have an agreement to pay off a debt and the payments stop, you simply resume the case or reopen the case, and it becomes something the judges reviews again. Yeah. Yes, sir, Tim.
So you talked about the program in the schools, the PROS program.
Mm-hmm.
Are you teaching students to do this, or are you teaching adults to do this?
Yes. The answer is the curriculum is set up so that it can address kindergarten, first grade, high school, and college level kinds of issues. Yeah. Yes, sir.
One more question at least.
I know, thank you for your question.
So before you have a mediation session, do all the parties to the dispute have to agree to attend?
Yes, it has to be voluntary. And that, I mentioned that many times we do this in real estate cases. In those circumstances, there's not a court order that's describing the requirement for you to participate. And we'll reach out to the other side and invite them to mediate, but we can't make them do it. And sometimes we're not able to help individuals seeking our assistance with a non-court ordered kind of case because the other party just declines. But once they're in the room, they've got a 74% chance that they're going to come to an agreement. Thank you. I'm sorry to take up your time.
No.